90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. My special guest is attorney Jim Brosnahan. He's with the law firm of Morrison Foerster. It's a global law firm with 1,000 attorneys scattered around the world. He's a very experienced trial lawyer with over 65 years of legal practice, and he's also the author of his new memoir, Justice at Trial, and we'll talk about that in a few minutes. Jim, let's just talk about what's going on in the world of law in the next few weeks and months. Donald Trump. In terms of lawyers controlling their clients, what are some lessons lawyers can learn from Donald Trump and his different legal matters?
Well, there was a great lawyer named Edward Bennett Williams who said, never take a case where you can't control it. And that's very good advice for most cases. By observation, Mr. Trump, President Trump, has difficulty in giving any control over to the lawyers. And so he appears very often to be doing things, sometimes in court, which are not productive. There are certain realities in courtroom work about the judge, showing respect for the judge, for example. Juries love judges for the most part, not always, but mostly they do. And that's very important. Not glowering at people, it's not helpful. And he tends to do that. He kind of dares people to convict them. And juries are very smart. They're very smart within your listeners out there. They go in there, listen to the evidence. They try to do the right thing. This will be a difficult case because people have voted for or against Mr. Trump, and that complicates it.
And we don't know exactly who will be on the jury in the various cases or what their thoughts will be and how they'll absorb all the information. But while he's sitting as a criminal defendant during any of these legal matters that involve criminal issues, he's going to be your advice to him would be to be on his best behavior and not incur the wrath of the judge.
Absolutely. Although there's been unusual cases where somebody has fought the judge and the jury has sided with them. I had one case in all the years where I thought that was true. The jury decided they didn't like the judge. It does happen, but it's very rare. The judge is a dignified person sitting up front. The law has said here, this is your judge. And they listen very carefully to what they're supposed to do. Think of it from their standpoint. Here they are, they're a truck driver, they work in a restaurant, now they're sitting in the jury box. There is, in this case, a former president of the United States. There's a lot at stake in this case, and they'll pay very close attention. I believe in collective intelligence, and I believe it in a jury box. You get 12 people, they're smarter than most lawyers.
But Donald Trump should leave the antics or the arguments to his lawyers, who are very highly respected lawyers. He should not show too much emotion or antics, at least in the courtroom.
I agree with that. And I think he would be well suited if he were to be calm, listen. The big question actually is he going to testify? It's a big question in every criminal case. Is he going to testify? Is he not? His lawyers will have something to say about that, but he has the right to testify if he wants to. And if he says, I'm going to testify, then he will do that. Whether he will come across as a believable person, that's the issue. Is he telling the truth on the question, whatever the question is in that case. As you know, he has four criminal cases, and they're quite different, actually. Is he telling the truth? And the juries are very good at thinking whether the person has just told us the truth, that he didn't know about this, somebody else handled this, whatever it might be. But if he comes across as an angry person, then all bets are off. And I think you saw that in the result of the personal injury case, the abuse case, actually, where the jury just whacked him for $400 million. That was partly because of the way he behaved.
And also in that case, I think the cross-examination was limited because his testimony was limited. But in a criminal case, his testimony would probably be longer and touch on more matters. And the cross-examination could be challenging for him and also for him refraining himself under cross-examination.
I had a trial that where the examination and cross-examination lasted for 9 days of the defendant, and he didn't do well.
And I'm not sure President Trump would be able to, as many people would be challenged, to keep his composure on cross-examination, depending on the nature of the questions.
Well, you'd have to know. You'd have to know. In a usual case, a non-political case, you would have a lot of practice of cross-examination. And you bring in a partner who cross-examines the person, runs them through it, and says, no, you can't say those things, and that kind of thing. And there's a lot of that. How much of that President Trump would tolerate is unknown, of course. The door is closed when they're talking about that. But I think he would have a problem with it from what I've seen.
Moving away from Donald Trump, and based on your years of experience, what are some keys to a lawyer persuading a jury?
Well, there's a lot to it, and it starts long before you get to the final argument. It's how you conduct yourself during the jury examination, for example, when you're picking the juries. How do you behave? What is your style? The fact that I approach it I approach it very politely and very sincerely. Here's a juror sitting there afraid I'm going to ask them, do they have a divorce, or were they ever arrested? And I am, and I'm very polite, and that's my style. And that's, I think, style of a lot of trial lawyers. You're trying to get information, trying to get answers as long as possible, but you don't want them to say why they're prejudiced. And so you want to be sure that you don't do that. Then during the case itself, you handle most of the witnesses with a polite approach, getting information, cross-examining, but there may be two or three or four that just deserve a really rigorous cross-examination. By the time you get to the final argument, the question is, how good is your case analysis? Do you understand two things? Do you understand what generally will work in a case? And do you understand this jury? I come from San Francisco. Somebody wants me to try a case in Nassau. There I am. Have I studied this group? I mean, do I really know how to pronounce the words even of your streets and your people and so forth? And then there's the question of the actual speech itself. And I taught speech to law students at Berkeley Law for 10 years. And I loved it, because what I found was a lot of young lawyers are very afraid of speaking. It's surprising because they go to law school, but they're concerned about it at a certain level. Practice is the point. Ladies and gentlemen of the jury, I have three things to tell you. These are the three things that matter in this case. I'm helping them. I'm making it easier for them. And hopefully I've figured out what the three things are. And now I tell you, number one, number two, number three. I'm explaining this as I go along. There is room for emotion by the lawyer in a final argument. You can use it in an appropriate circumstance. Some young lawyers in particular have been brought up not to use emotion, but I think it should be in their toolkit. And you practice before the specific trial, but then during your life, you're practicing the elements of speech. And there are these: tempo, you got to go at the right speed; volume, you've got to be heard by all 12 jurors and the alternates; tone, you've got to find a good tone that's good to listen to and easy to listen to; emphasis, this is the point that I really want to get across to you, ladies and gentlemen. This is it that I'm emphasizing. Clarity, each word is clear, and that helps if you're not in a hurry. And pauses. He had a gun. You pause. You let it sink in. So we work with the fundamentals. I'm still doing some teaching actually on LinkedIn and having fun doing that.
And as you mentioned, variety is important, dramatic pauses, raising or lowering your voice to emphasize something. And just so you don't want to sound so monotonous, you want to emphasize and put weight on certain words or terms that you may want to be important.
Ken, you just hit a very key point. You'll be surprised how many lawyers tend to speak quietly and flatly and goes along, and no particular word is emphasized, but rather I'm going to put this information out and I expect the jury to put it all together. Well, there's more to it than that. You have to make an impact with your speech and your voice, not my voice, but your voice. And that's something that can be learned, and practice helps that a lot.
And I want to come back to the rule of threes in a moment, but I just want to mention we're talking with Jim Brosnahan. He's with the firm of Morrison Foerster. It's a global law firm. As you can hear from his discussion, he's been a trial lawyer with over 65 years of legal experience, and he's giving valuable information to clients and lawyers and many good tips on do's and don'ts. And you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. If you missed any portion of the program or you want to tell someone else about it, just go to the podcast at nccradio.org. So in terms of the rules of three, do you think they apply to almost anything going on at a trial or in let's say, a lecture?
I'll tell you, I love the laws of three. I use it all the time. I'm writing another book right now. I love there's something about it's mystical. If you ask me, well, why is that? I have no idea. I think it comes out of the caves of the old days or something, that people just love threes. I have 3 points. 1, 2, 3. It sounds good. And the organization point is the important point. The jury can follow. If I say 3, and then I say one is about this and that and the other thing. Now I'm going to go to 2. 2. You're not talking down to them. You don't do that. But you make it easy. You break it up. Question in this case, ladies and gentlemen, is the intent of the defendant. Certain things happen. You heard about that. But you've got to decide, what was he intending? And that's very difficult in this case because of 3 things, 1 and 2 and 3.
Or there's maybe 3 ways to analyze a situation, one on the left, one on the right, or somewhere in between.
Absolutely. And, if you're not sure, that's called a reasonable doubt. And I've got this chart here, and I've got the different grades of consciousness. For example, he might be guilty. That's not enough. Or he could be guilty. That's not enough. Or it's possible that he's guilty. That's not enough. No, as I go up this chart, it has to be beyond a reasonable doubt and on the defense of a criminal case. And that's very often the public defenders, that's the only defense they have in the case. The facts are not good.
And if it's the rule of three, whether it's a presentation or something at trial, you're at some point, maybe in your conclusion, you're going to help the jury or the audience perhaps eliminate the two possibilities that you don't like, so they conclude along with you. It has to be that third one.
Well, you are, and suppose you're going down to the school board and you don't like something that they have, and you have 3 minutes. It's good to say, I have 3 points. Here's one. We've always done it the other way. 2, blah, 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 and 3, blah, blah. These are all 3 points in favor of whatever it is I'm trying to convince them of. There's another little tip that I always use myself, and that was start slow and take a deep breath. If you start slow, that will get you on the right track. The great tendency is to start fast because the nerves have taken over and you're talking like this. And once you start that, there's a temptation to keep going too fast. That's where you get your pause. You want pauses. You want emphasis, picking out which words really matter beyond a reasonable doubt, says the prosecutor. It's a reasonable doubt. It's not any doubt. It's a reasonable doubt. It has to be, you have to think it's reasonable to doubt it. Well, that's not true in this case.
And I like your idea about starting off slowly. I like to suggest it's like the entrance ramp to a highway, especially with a long ramp where you're getting up to a certain speed, so then you can get into the first lane. And you might be changing lanes and changing your speed as your presentation goes, but you're starting out slowly and to reach your highway speed.
There's really no reason to be terrified about giving a speech. You can examine yourself. What are you afraid of? You've thought it through. You know what you're going to say. You've written it out, but now you're not going to use your notes. You want to get to a point in speaking where you're not using notes. Why? Because you want to look at your audience. There's the Board of Education. Are they reacting in one way negatively to what you're saying, affirmatively? You want to read that audience as you're talking. That takes a while to get comfortable doing it, but there's an awful lot of books out there on giving good speeches, and most of them are similar, but you can get one and see what they're saying, and it'll help your speech. Some people are helped by the fact they were teachers, for example, and all you do is stand up front and talk, so you get pretty good at that.
And even if you weren't a teacher, you're used to communicating with a friend or relative as a child, and you're looking at them, and you're having, in one sense, in some settings, giving a speech is like having a conversation. You're having a conversation with the judge, you're having a conversation with the jury, and maybe you just focus on one or two of them and have your conversation.
Very much so. I have 2 judges in my family. My wife was a judge for 40 years, and my daughter Amy is a judge in Minnesota. And I've talked to them about what their reaction is when, in this case, the lawyer is whining. You'd be surprised how much whining there goes on in courts. And they hate it. I mean, they really don't like it.
Is it also bad if you talk about the witnesses or your adversary or the client or the other client in a derogatory tone?
Well, that depends. I used to tell clients they'd come to me and they would say, this one's against me, that one's against me. I would tell them we're only auditioning for 1 or 2 people. We can't defend the case on the grounds that the whole world is against you. But those 1 or 2 people, some lawyers, very good lawyers, believe you shouldn't try to break a witness. I don't agree with that. If it's a key witness and you have the material to break that person, then that's my mental state. I don't necessarily show it at the beginning by the tone of my voice. We're back to the voice is crucial in any speech. You go and talk to your boss about a raise, your tone of voice is important. You want to be kind of informative about the company and you like it and you're enjoying the work, but you really, you need a raise.
And you might find some areas where the hostile witness is going to be in agreement with you, and then you're segueing into those areas where you have a difference of opinion.
Very good point, and you probably want to take up the good points first before you get into the attack mode, and get everything good out first, and then go to the real cross-examination.
And maybe maybe they didn't really see the things they thought they saw. Maybe it was some idea, or they filled in the gaps themselves. They didn't really perceive those events.
Well, there's been an awful lot of literature in the last 50 years on eye identification. There have been books, very good books written. People think that they identified somebody. And yet the argument against that is we've all done this one time or another. We go into the store and we see a person at a distance and we think it's Harry. And so we walk up and we almost say, Harry, good to see you. And then we realize it's not Harry. That's a real example of how mistakes can be made. And in a criminal case, ladies and gentlemen, the mistake that could be made here, if that's really the only evidence in the case, could cause an unjust verdict. You don't want to be part of that.
And we also may not remember about a series of events. We may not remember about what an accident scene looked like or how an accident occurred. We might remember part of it, but we might fill in some of the details.
That's exactly right. It's true of all of us. The perception issue. Did we have something else on our mind? Did we not have our glasses on? Anything like that is helpful for the defense. Building up for the prosecution is, of course, that they were concentrating on this event and knew exactly who the person was and heard that person say, and I'll never forget it when he said that.
I just remind our listeners, we're talking with Jim Brosnahan. He's a trial lawyer with the global law firm of Morrison and Foerster, with offices around the world. He's the author of his new memoir, Justice at Trial, and you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. If you missed any portion of this program, feel free to go to the website at nccradio.org. Jim, just tell us a little about the book and what's covered in the book, Justice at Trial.
Well, it took me three years to write it, and I thought I was a really good writer, and when I started really working on it and getting some good instructions by two editors, I began to see the craft of writing in a whole different way. And the point of the book is to take the reader, whether they're a layperson or a lawyer, inside courtrooms for real cases and what happened. And the cases were picked by me because I had a lot to pick from to represent current issues. For example, I had a case involving the Mexican border, immigrants coming across the Mexican border. I had a prosecution of Caspar Weinberger, who was the Secretary of Defense. I had a case involving a person who was helping out to try to free the Philippines, and he was accused of doing certain things, but the FBI had cheated on the evidence, and it took me a while to figure that out. But those kind of exciting renditions and the suspense of trials, waiting for juries to come back, is all in the book, and it's doing well. It's available on Amazon, among other places, and you can order it at any bookstore.
And just tell us also the website for your firm where
Yeah,
Listeners can learn more about you and
yeah.
your work. Yes.
Sure. We're Morrison Foerster. You can find us on Google immediately. And my website is jbrosnahan, Brosnahan, at mofo.com. And got some material there. On LinkedIn, it's interesting you're asking me about speech because I have a whole series of LinkedIn points on how to improve your speaking. And I've got I've got a lot of followers because I know they're interested in that. I also put up commentary on the U.S. Supreme Court because I've lectured on that for years.
So just tell us how our listeners, whether they're lawyers or non-lawyers, could find all this information on LinkedIn.
On LinkedIn, it's Jay Brosnahan on LinkedIn. And I put out 2 or 3, depending on the events and all of that, 2 or 3 posts every week. And I've got, I don't have a huge amount of followers, but I have 9,200 followers at the moment. So that's respectable. And I'm putting out tomorrow morning, for example, I know this won't be broadcast until later, but 10 things for the jury, the LinkedIn people to look for in Mr. Trump's latest trial, the first criminal trial, which is being tried in April.
Okay, and just again, your LinkedIn is JBROSNAHAN.
Yes. Yep. And I usually put on 2 or 3 posts about various things having to do with law, but also speaking and how to improve your speech. Latest legal developments. I listened to the U.S. Supreme Court arguments, for example, which you can get, and then I comment on those and give my ideas about them.
It sounds like a lot of good stuff there that you put out on LinkedIn. I'd like to thank our guest, Jim Brosnahan, for being our guest on Law You Should Know. And please join us next week at this same time on 90.3 WHPC for another program on Law You Should Know. And you can listen to the podcast at nccradio.org.